Hey there, curious minds. Welcome back to the Deep Dive, your go-to for cutting through the noise and getting truly well-informed. Have you ever, scrolled through a job ad or maybe signed an employment contract or even just wondered about your rights at work and thought, what's actually underpinning all of this?
It's a vast legal landscape, it really is. But today we're taking a deep dive into the fascinating world of South African labor legislation.
Indeed. And it's something, many people interact with these laws every single day without fully grasping their profound impact, both good and, well, sometimes challenging too.
So our mission today is to unpack the core pillars. You've got the Labor Relations Act, the Basic Conditions of Employment Act, and the Employment Equity Act. We want to reveal not just what they say, but why they were created in the first place and why they matter to you, whether you're an employee, an employer, or maybe just someone interested in how our society strives for fairness in the workplace. We've sifted through the original acts themselves, court case analyses, expert commentary, trying to pull out some surprising facts and maybe a few real-world aha moments for you.
Okay, let's unpack this then. Yeah, our goal is really to give you a shortcut to understanding these essential legal safeguards, sort of cutting through the legal jargon to get to the truly important bits of knowledge.
Right, and to really appreciate these laws, I think you need to understand their origins, where they came from. Historically, the relationship between an employer and employee, well, it was largely governed by common law contracts, just the agreement.
So if it was all about the contract, where did it fall short? For the average worker, I mean. What was the big limitation there?
Exactly. That's the key question. The big limitation was that common law, while it upholds agreements, it didn't inherently prioritize fairness or equity. Not really. It simply enforced the contract as written. And this often meant the party with less power, usually the employee, was, well, vulnerable. It created a real need for laws to step in and protect against exploitation.
Yeah, that makes so much sense because without that legal backing, the power dynamic is just completely skewed, isn't it? And this next part is truly foundational, I think. It really shifts how we think about the workplace. Our labor laws are actually guided by the South African Constitution itself, particularly its fundamental rights like freedom of association.
Yes, absolutely. And not just our Constitution, but also international standards, those set by the International Labor Organization, or ILO. There's the Declaration of Philadelphia, a key ILO document, and it famously states that labor is not a commodity. Just think about that for a second. It's a powerful idea, isn't it?
It really is.
It emphasizes that human effort isn't just another product to be bought and sold. It stresses the importance of freedom of expression, the right to form associations, and the pursuit of material well-being with dignity and, crucially, equal opportunity.
Wow, labor is not a commodity.
Why?
That's a profound thought. It really underscores the human element behind all these regulations.
Absolutely. And this global and constitutional influence means our legislation aims to align with universal standards, promoting social justice and economic development right here at home. And a crucial player in shaping these very laws is NEDLAC, the National Economic Development and Labor Council. They bring together labor, business, government, and development groups.
All the stakeholders.
Exactly. To find common ground and reach consensus on social and economic policy. It's quite a unique model of collaboration, actually.
Okay, so with that big picture in mind, let's dive into the specifics. Maybe start with the Basic Conditions of Employment Act, the BCEA. It seems like the day-to-day guide, really setting the minimum standards for most employees.
That's right. The BCEA sets the floor for employment conditions, which you can at least expect, the bare minimum. And it covers almost everyone, which is important to remember. However, there were some very specific exclusions, things like members of the National Defense Force or senior managers, those who have the power to actually hire and fire. Also, casual employees working less than 24 hours a month or genuinely independent sales staff who are largely unsupervised. They aren't typically covered by all its provisions. The key is it's designed to protect the average worker in a standard employment relationship.
Right. So what does this actually mean for your working hours? How much is too much, according to the BCEA?
Well, the BCEA keeps things fair by regulating ordinary hours, overtime, and rest periods. It tries to strike a balance. For example, your employer generally can't just ask you to work more than 10 hours of overtime in a week. There are limits. Now, a collective agreement can increase this, maybe to 15 hours a week for a short period, but that's an exception. And if you do work overtime, you must be paid at least 1.5 times your normal wage. Or you could agree to pay time off instead. The Act really ensures you're not just working endless hours without proper compensation or rest.
And beyond the clocking in and out, what about actual breaks? Time to recharge?
Crucially important. You're entitled to a daily rest period of 12 consecutive hours between shifts, and a weekly rest period of 36 consecutive hours, which, unless you agree otherwise, usually includes Sunday. This isn't just a nice to have. It's fundamental to health and safety, preventing burnout, ensuring you have a life outside work.
Makes sense.
And if you happen to work on a Sunday occasionally, maybe fill in. You get double pay, recognizing it's outside the norm. If Sunday is part of your ordinary week, it's 1.5 times.
Okay. And the Act also covers various types of leave, right? Which is super important for life's big moments and, well, unexpected challenges.
Absolutely. Think about annual leave. Most full-time employees get 21 consecutive days a year, that much-needed break. Then there's sick leave. You're entitled to 6 weeks of paid sick leave in a 3-year cycle. This is vital protection. It means you don't have to choose between your health and your income when you're genuinely unwell.
Yeah, that's huge.
Yes, employers can ask for a medical certificate if you're off for more than 2 days straight, or if they notice a pattern, frequent absences.
Yeah.
That's within their rights.
Okay. And for growing families, that's such a big life event. What does the BCEA offer there?
Right, for pregnant employees, the BCEA provides 4 consecutive months of maternity leave. And what's critically important here is that a pregnant or breastfeeding employee cannot be asked to do work that's hazardous to her or her child. That's a key protection. The Act also makes arrangements for 2 30-minute breaks per day for breastfeeding or expressing milk during the first 6 months. And it specifically says a toilet is not considered a safe or hygienic space for this.
Good point. Important clarification.
Definitely. It acknowledges the practical, physical needs of new mothers in the workplace. And for all new parents, including adoptive and commissioning parents, there's at least 10 consecutive days of parental leave. Now, this is typically unpaid leave from the employer, but you can claim from the Unemployment Insurance Fund, the UIF. And for broader family needs, full-time employees get 3 days of paid family responsibility leave annually for things like a child's birth or sickness, or sadly, the death of a close family member. These provisions really aim to support that work-life balance for families.
Okay, that covers leave. What about getting paid? The national minimum wage is a big topic, affects so many people directly.
Yes, the national minimum wage is a cornerstone of fair pay.
Right.
As of 2023, no worker could be paid below about R25 an hour. It was at 25.42, I believe. It's a crucial safeguard against exploitation, really setting a baseline. This replaced previous different rates for farm workers or domestic workers, setting a more universal standard. Employers are also obliged to give you written details of your job and working conditions, your wage, hours, leave, any deductions. Transparency is key. And here's a really important point. Employers can't just make deductions from your pay willy-nilly. They can only do it if you've agreed in writing, or if it's required by law, a collective agreement, a court order, or an arbitration award. It protects your earnings.
That's good to know. So what about ending employment? If you're just starting a job, say you've been there less than 6 months, how do notice periods work if things don't pan out?
Right. Well, for shorter periods of employment, typically less than 6 months, the standard notice period is 1 week. But that extends. If you've been there longer than a year, it goes up to 1 month notice. This structure provides a degree of stability and predictability for both sides when an employment relationship ends. And it's worth remembering, there are labor inspectors out there. Their job is to monitor and enforce compliance. They can issue compliance orders and even impose fines for non-compliance, making sure these basic conditions are actually met in practice.
Okay, so the BCEA lays out those individual minimums, but true workplace fairness often needs more, like a collective voice. That's where the Labor Relations Act, the LRA, comes in, right? It creates the framework for how employees and employers can organize and, importantly, resolve disputes together.
Exactly. The LRA's purpose is quite broad. It aims to advance economic development, social justice, and labor peace. Ultimately, it's about working towards a more democratic workplace. It gives real effect to those constitutional rights and ILO obligations we talked about earlier. It provides a structured environment for collective bargaining and dispute resolution.
And a cornerstone of the LRA you mentioned is freedom of association. What does that truly mean for individuals in the workplace? What can they do?
It's a fundamental right. It means employees can form and join trade unions and also workplace forums without fear of reprisal. They can't be punished for it. And employers have the same right, the reciprocal right, to form employer organizations. Critically, no one can force or threaten an employee to join or not join a union or to give up their membership, nor can they stop them from exercising their rights under the Act. This freedom really empowers both sides to act collectively and protect their interests.
So once employees form a union, the LRA gives them specific organizational rights to actually function effectively. What do those look like in practice?
Yeah, these rights are practical tools for unions. They're not just symbolic. They include things like the right to access the workplace, to recruit members or hold meetings, usually outside working hours, the right to conduct elections for union leadership, and to have stop order facilities for union dues, which just makes it easier for members to pay their subs. Now, a union that represents the majority of workers in a workplace gets more rights. They can appoint shop stewards or union reps. They can receive necessary information from the employer, though there are safeguards for confidentiality, of course. And they can establish thresholds for representation. These rights ensure that unions aren't just paper organizations, but can actively represent and serve their members.
And collective agreements sound central to this. What makes them so powerful compared to individual contracts?
They are incredibly powerful. Once agreed upon between a union and employer, they are legally binding on all the parties for the agreed duration. And here's the key thing. They can actually override or vary individual employment contracts. So an agreement negotiated collectively can set better terms and conditions, maybe higher wages or more, leave for everyone it covers, even if their individual contract said something different.
Wow. Okay.
And these agreements must include procedures for resolving disputes about how they're interpreted or applied. Usually this starts with conciliation, trying to find agreement, and then moves to arbitration if needed. This applies to things like agency shop agreements, where non-members pay a fee, or closed shop agreements, where membership is compulsory. Those require specific ballots and a 2/3 vote, highlighting their significant impact.
You also mentioned bargaining councils. They sound like quite powerful entities in their own right. What's their role in all this?
They really are. Bargaining councils are essentially like mini parliaments for specific sectors or geographical areas. They're set up by representative unions and employer organizations in that sector, and they have extensive powers. They can conclude and enforce agreements for the whole sector, resolve disputes within that sector, and even establish things like pension or medical aid funds. What's particularly significant is that the Minister of Labor can extend their agreements to cover non-parties employers and employees who weren't part of the original negotiation, provided the council is sufficiently representative.
So they can set standards for an entire industry.
Exactly. It ensures that fair standards are applied broadly, preventing companies from undercutting competitors by offering much lower wages or conditions, even if they weren't part of the council initially.
Okay, now what about strikes and lockouts? They often make headlines and can be quite contentious, obviously. How does the LRA handle those?
Right. The LRA regulates the right to strike for employees and the recourse to lockout for employers. These are seen as legitimate tools in collective bargaining, but they are regulated. These are protected actions, meaning you generally can't be dismissed for participating in a legal strike, but only if specific conditions are met. The issue in dispute must first have been referred to a bargaining council or the CCMA, and then either a certificate saying the dispute remains unresolved must be issued, or 30 days must have passed since the referral. You can't just strike immediately. Also, you generally can't strike if you're bound by an existing arbitration award or a collective agreement that already covers the specific dispute.
Okay, procedural steps are important.
Very. And a significant recent amendment focuses on picketing rules. Commissioners are now compelled to try and get the parties to agree on picketing rules beforehand. The aim here is to try and curtail violence and unrest during industrial action, pushing for more orderly and peaceful strikes or protests.
That makes sense. Beyond stripes, though, how does the LRA promote broader employee participation, giving workers a real voice within their workplace day to day?
That's done primarily through workplace forums. These can be established in workplaces with over 100 employees, usually initiated by a representative trade union. Now, they aren't about bargaining over wages. That's for the unions. Workplace forums are more about promoting the interests of all employees, unionized or not, and enhancing efficiency through cooperation. They have the right to be consulted by the employer on matters like proposed changes to disciplinary codes or measures to advance disadvantaged persons or changes to social benefit schemes. Consultation means the employer has to listen and consider their input.
So, consultation on some things.
Yes, and on other issues, they participate in joint decision-making. This is stronger than consultation. This applies to issues like health and safety measures, changes in work organization, the introduction of new technology that impacts workers, and changes in employee numbers, like retrenchments. Critically, for this to work, employers must disclose all relevant information needed for effective consultation and joint decision-making. Though, of course, this has to be balanced against potential harm to the business or violating individual employee privacy.
That seems like a potentially powerful tool for cooperation. So if an employee feels their rights under, say, the LRA or BCEA have been violated, where do they actually go for help? What's the pathway to resolution?
The LRA establishes a pretty robust dispute resolution system. You don't just have to go straight to the regular courts. The Commission for Conciliation, Mediation, and Arbitration, or CCMA, is often the first port of call for many disputes. It's designed to be accessible and relatively quick. They offer conciliation, trying to help the parties reach an agreement themselves, and arbitration if that fails, where a commissioner makes a binding decision. For more complex legal matters or for reviews and appeals of CCMA decisions, we have the Labor Court. It's a specialized superior court, like a high court, but focused only on labor law. And the ultimate appeal body specifically for labor matters is the Labor Appeal Court. This structured approach helps ensure disputes are resolved efficiently and fairly by people with expertise in labor law.
Okay, that's helpful. Now, shifting gears slightly to fairness within the workplace and ensuring everyone gets an equal shot, let's talk about the Employment Equity Act, the EEA. What's its core purpose?
The EEA is really pivotal. Its main aims are to eliminate unfair discrimination and actively promote employment equity. Fairness and representation. It directly prohibits unfair discrimination on a really broad range of grounds. We're talking race, gender, sex, pregnancy, marital status, family responsibility, ethnic or social origin, color, sexual orientation, age, disability, religion, HIV status, conscience, belief, political opinion, culture, language, birth. It's comprehensive.
A very long list.
It is. The underlying principle is that everyone deserves to be judged on their merit and ability to do the job, not on characteristics that are completely irrelevant.
And affirmative action is a key component here, right? It's often talked about, sometimes misunderstood. How does the EEA define it?
It is key and often misunderstood, you're right. For what are called designated employers, and this typically means those employing 50 or more people, or sometimes based on turnover, the Act mandates affirmative action measures. The aim is clear: to ensure equitable representation in all job categories and levels for people from designated groups. These are groups historically disadvantaged in the South African workplace, primarily Black people, women, and people with disabilities. This involves practical steps, developing and implementing employment equity plans, consulting with employees on these plans, conducting a thorough workforce analysis to see where the gaps are, and setting numerical goals and targets to achieve better representation over time. It's not about rigid quotas, but about actively identifying and removing barriers and creating real opportunities for advancement.
So it's not just about stopping discrimination when it happens, but actively working towards a workforce that reflects the broader society. What are employers actually required to do with these plans?
Well, designated employers have clear obligations. They must prepare and implement successive employment equity plans. It's an ongoing process. They need to assign a senior manager to be responsible for overseeing this process. And then they must submit these plans and regular progress reports to the Director General of the Department of Labor. The Director General's office reviews these reports for compliance. And failure to comply or failure to make reasonable progress towards the set goals can lead to consequences. This could include recommendations or even referrals to the Labor Court. The Act also calls for measures to address disproportionate income differentials, promoting fair pay across all levels and groups within the workforce. It's a systemic approach, trying to tackle inequality from multiple angles.
Okay. Now, this next point you mentioned earlier sounds like a huge aha moment for many people, and it seems to cut across all these acts. We've talked a lot about employees, but what exactly defines an employee in the eyes of the law, especially when contracts sometimes try to label people differently, like independent contractors?
Yes, this is a critical distinction, especially today with the rise of the gig economy and more flexible work arrangements. It causes a lot of confusion and disputes. The LRA defines an employee quite broadly. It includes someone, excluding a genuine independent contractor who works for another person or the state and receives payment, or even just anyone who assists in carrying on an employer's business. But here's the crucial part. The wording of a contract isn't the final word. It's not decisive on its own. You can't just call someone an independent contractor in a document to avoid your legal obligations as an employer if the reality of the relationship looks like employment. The substance matters more than the label.
That's fascinating. So the label isn't enough. What tests do the courts or the CCMA use them to figure out the reality, to see past the contract's title?
They use a few tests, often referred to collectively as the dominant impression test or the reality test. No single factor automatically decides it. Instead, they look at the whole picture, the overall relationship. There's a presumption in the law now. A person is presumed to be an employee if certain factors are present. For instance, if the manner or hours of work are subject to the control or direction of the other person, if they form an integral part of the employer's organization, if they've worked for that person for an average of at least 40 hours per month over the last 3 months, if they're economically dependent on the person they work for, if they're provided with tools of trade or work equipment, or if they only work for or render services to one person. If just one of these factors is present, the law presumes they are an employee, and the burden shifts to the employer to prove that they are not an employee, but a genuine independent contractor. It's a powerful protective measure.
Wow. Only one factor needs to be present for the presumption. That really shifts the balance. And you mentioned we have some fascinating cases that illustrate this perfectly.
Indeed. Real-world examples make it clear. Consider the State Information and Technology Agency, COIDA, case. It's a well-known one. There was an individual who, for various reasons, had previously been restricted from working directly for the SANDF or its service providers. So he set up a closed corporation, a CC, and used that CC to bill COIDA for his IT services. On paper, he looked like an independent contractor running his own business. However, when COIDA decided to end the relationship, effectively retrenching him, he claimed employee benefits like severance pay. COIDA argued he was a contractor. But the Labor Appeal Court looked beyond the CC structure. They examined the reality. They found he was clearly under COIDA's control regarding how and when he worked. He was an integral part of their IT operations, and he was economically dependent on COIDA. The court concluded the CC was merely a front, a way to disguise what was, in reality, an employment relationship. So he was declared an employee and entitled to the benefits.
That's wild. It really shows the courts are willing to look past the surface arrangements. What about a more recent one that many people might encounter, Uber drivers?
Ah, yes, the Uber cases. These have come up in South Africa, too, notably at the CCMA. It highlights how technology complicates these definitions. Uber, as you'd expect, argued its drivers are independent contractors, partners, using their platform. They have flexibility, use their own cars, etc. But the commissioner in one key CCMA case looked at the overall reality again. Drivers rendered personal services to Uber. The agreements often had no clear termination date, suggesting an indefinite relationship unlike a specific project contract. While drivers had some independence, Uber controlled crucial aspects: performance standards, pricing algorithms, route suggestions, and crucially, Uber could deactivate their app, effectively firing them. This gave Uber ultimate control. The finding was that the drivers were deemed an essential part of Uber's core business of providing transport services. Therefore, in that instance, they were found to be employees for the purposes of the LRA. It's a great example of how these old legal principles adapt to new forms of work.
So the takeaway is huge. Even if a contract explicitly states independent contractor, if the reality of the working relationship, the control, the integration, the dependence points towards employee status, the law will likely treat them as an employee. And you mentioned there's even a specific part of the LRA, Section 200B, that targets this.
Yes, Section 200B directly addresses disguised employment. It was introduced specifically to prevent arrangements where employers deliberately structure things to look like contracting, purely to deny employees their rights and protections under labor law. It adds another layer of protection against sham arrangements. It's a vital safety net.
Okay. And the legislative framework also tries to address other modern employment challenges, right? Especially for workers who might be in more vulnerable positions.
Definitely. The law has had to evolve.
Like fixed-term contracts, those seem like they could be easily abused if not carefully managed.
Yeah, precisely. And they often were. So the LRA was amended to address this, particularly for employees earning below a certain annual earnings threshold. It changes over time, but was around $205,000 at one point. For these lower-earning employees, fixed-term contracts are generally limited to 3 months. That's the default. They can only be longer than 3 months if there's a genuinely justifiable reason. The law lists specific reasons, like replacing another employee who is temporarily absent, like on maternity leave, a temporary increase in workload, but even that is usually limited, say, not exceeding 12 months, or if the person is working on a specific genuine project that has a defined limited duration. Without such a clear, objective justification, a contract that goes beyond 3 months or is repeatedly renewed will automatically be deemed to be permanent employment.
That sounds like a significant protection against keeping people in insecure rolling contracts indefinitely. And there was a big case about this involving Metro Rail, wasn't there?
Yes, the Metro Rail case was quite high profile. It involved about 260 employees who had been kept on rolling fixed-term contracts for years. They were doing ongoing, permanent-type jobs, but were denied the benefits and security of permanent employees. The CCMA eventually ruled that they should be made permanent employees with full benefits, backdated in some aspects. It strongly highlighted that employees shouldn't bear the brunt of poor planning or mismanagement by the employer. The ruling reinforced that you can't use fixed-term contracts simply to avoid providing permanent employment benefits for ongoing work. Even if, arguably, without those contracts, maybe some of those people wouldn't have had jobs at all. The law prioritized the protection against precarious work.
That's a really important principle. And what about the use of labor brokers or temporary employment services, TES? How are workers placed through them protected?
The LRA also clarifies the situation with TES, or labor brokers. It recognizes them as the legal employer. However, and this is crucial, both the TES and the client company where the employee actually works are jointly and severally liable if there's any contravention of the BCEA, a binding collective agreement, or an arbitration award. This means if the worker isn't paid correctly or their basic conditions are violated, they have legal recourse against both the labor broker and the company they are placed at. It's a vital protection because it prevents the client company from simply saying, "Not my problem, talk to the broker." Both are responsible for ensuring compliance.
Wow. What a deep dive indeed. We've really journeyed through a lot. From the foundational principles moving beyond simple contracts towards fairness, explored the daily protections of the BCEA, navigated the collective bargaining structures of the LRA, and understood the equity-driven mandates of the EEA. We've seen how the law works hard to define who an employee truly is, looking past the paperwork to the actual reality, and how it constantly tries to adapt to protect vulnerable workers in this ever-changing world of work.
Indeed. I think it shows that South African labor legislation is quite comprehensive and certainly dynamic. It's constantly trying to strike that difficult balance between various competing interests, protecting employees, empowering collective action, promoting equity, but also considering the needs of business and fostering economic development. It gives effect to fundamental constitutional rights, international obligations, and reflects the unique socioeconomic context of the country. It's complex.
Absolutely. So after covering all that ground, what does this all mean for you, our listener? And what final, maybe provocative thought can we leave you with after today's deep dive?
Well, I think one thing that comes through clearly, and it's reflected in much of the commentary around these laws, is this ongoing tension. On the one hand, there's the clear necessity, rooted in our history and Constitution, to robustly protect employees from exploitation and promote fairness. But on the other hand, there's a need to foster economic growth and, crucially, job creation. Sometimes the very laws designed to protect workers are criticized, rightly or wrongly, for making employment too rigid, too expensive, and potentially stifling the creation of new jobs, especially for small businesses. So this raises a really important question for all of us, I think. In a world with evolving work arrangements, gig work, remote work, automation, and facing significant economic pressures, how do we as a society collectively ensure that we maintain and even strengthen robust protection for workers, while simultaneously creating an environment where businesses, large and small, can thrive, innovate, and actually expand employment opportunities for everyone? What part do you think we all play, employees, employers, government, unions, individuals, in finding that very delicate, maybe ever-shifting balance?
That is a powerful thought to chew on. Finding that balance. It's the ongoing challenge, isn't it? Thank you so much for joining us on the deep dive today. We really hope this exploration has given you a clearer understanding and perhaps sparked some further curiosity about this intricate, vital world of labor relations. Until next time, keep digging deeper.